Hi, welcome to the Win Legal channel. This is the channel where we provide tips, tactics and strategies to help you through your civil dispute. And today we're talking about 5 things you need to know about litigating in the United Arab Emirates. Most people know of Dubai and Abu Dhabi, but in fact there are more Emirates that comprise the entirety of the United Arab Emirates. Win Legal support clients who have litigation going on within the United Arab Emirates, and in particular those where there are English jurisdiction clauses. Many of our clients live within the UAE or the wider GCC and have litigation going on in England. But this video is about what you need to know about litigating within the UAE, including within Dubai. The first thing is that commercial disputes within the UAE tend to be dealt with by way of litigation or arbitration. The idea of mediation isn't as common. So if you are finding yourself in a dispute, it would probably be worth considering some sort of arbitration in the first instance to avoid perhaps the time and cost of having to litigate later on. It's very important that litigation within the UAE is very much court driven. The courts set the timelines, they set the experts that would be helping, and they generally take a very controlled approach to how litigation is dealt with. Unlike in the United Kingdom, where different cases at different courts or higher courts are sometimes looked at, in the UAE there is something called the civil law system, which basically looks at the statutory provisions when making a decision. Judges don't look at previous cases, but they look at the case as it is in front of them and apply the statutory law. In the UK and in other common law countries, there is a certain burden of proof. For example, in the civil system, the courts may look at the balance of probabilities. In the criminal system, the court may look at what is beyond reasonable doubt when looking at the standard of proof that has to be met. However, in the UAE, such burden of proof does not exist. It very much depends on how the judge is on the day and whether the judge is being influenced in the right direction when making their decision. The next thing to bear in mind that within the UAE, most of the proceedings are done on paper. There is very little by way of oral evidence. Now, there may be exceptions within the free zones, but generally written evidence is king. So it's very important that whichever evidence you seek to rely on is written. And unlike in perhaps other countries, there isn't a process of discovery or disclosure. So whichever party wants to rely on their case is required to provide as much of the evidence that they seek to rely on within their claim. Now, the thing I should emphasize is that there is something called the Dubai International Financial Centre, and that's abbreviated as being the DIFC, and they have a different method in which they work. They use the common law principles. A lot of the work is dealt with in English, whereas on the mainland, Dubai, a lot of it's dealt with in Arabic. So it's very important when you're litigating to assess whether the case is going to be heard within the UAE and the civil system or within the DIFC, which is a free zone within Dubai, which would use a different system, i.e. the common law system. Just some very quick things to bear in mind. Whereas in England, for a breach of contract, the limitation period is 6 years, in the UAE it's actually 15 years. So it's something that I think is pretty impressive and quite interesting. And the other thing to bear in mind that in the UAE, an Arab advocate is usually required to present the case. So whilst international lawyers can prepare the case behind the scenes, it is an Arab advocate that would go in front of the judge to present the case. We hope you don't find yourself in any dispute, but if you do and you do need any guidance, please feel free to visit our UAE desk by visiting www.win.legal. Thank you very much for listening.